Hi, it's Louise from Mobile People Solutions, and today I have Michelle, a local business owner, with me, and she wants to understand how she should respond if a disciplinary situation arises.
Thanks for allowing me to pick your brains because this is a very delicate situation. If a disciplinary situation does arise, what are the processes or procedures that an employer should follow?
Michelle, you've used the right language immediately. It is about policy, it is about procedure, it's about process. So the first thing that I do is always consult the disciplinary procedure. And the reason I do that is that a tribunal will automatically find a dismissal to be unfair if you haven't followed a basic process. You should consider whether you can achieve the desired outcome through informal means. You don't always have to proceed down a formal disciplinary route, which has a sanction at the end of it typically. So if you can achieve the desired outcome of behavioural change through an informal route, then that is obviously the best route to proceed. You must ensure you've got sufficient evidence to proceed down a disciplinary route because we're dealing with employees. We're dealing with human beings. And there's trust issues if you proceed through a disciplinary process without having enough evidence to have taken that course of action. Employees have certain rights in a disciplinary process. They have the right to have time to prepare their case. They have the right to have representation with them. They have the right to see the evidence that you're going to use against them effectively. And if there is a sanction applied, they have the right to appeal against that decision. I would absolutely encourage everyone to treat your employees with respect through this process. It's not a witch hunt. You should not go in prejudging the outcome. You should absolutely be mindful that this could potentially result in a final written warning, but that isn't the automatic default position. There are other alternatives. They have an opportunity to present their case, and if they present evidence that hasn't previously been made known to you, you should adjourn the disciplinary while you go away and investigate this new evidence that has come to light. Any decision that you take should be reasonable and balanced and fundamentally consistent with how you have treated employees. So if you decide not to take a disciplinary at this point in time, you need to be mindful that that's the way you're going to have to approach in the future, because you set an internal precedence within your organisation. If you are mindful to summarily dismiss, or if you find the employee guilty of gross misconduct, you need to always consider whether there's some sanctions short of dismissal. Just because it warrants or it meets the definition of gross misconduct does not mean to say that summary dismissal is always the natural outcome. Demotion is an alternative that you may use in that scenario.
Goodness, there's a lot to consider there.
Yeah.
And in terms of, I suppose, in your experience, when does a disciplinary situation usually arise?
There's usually two types of disciplinary scenario, and they fall under two broad headings, one being misconduct and one being capability or conduct and capability. The vast majority would fall under the misconduct banner. So bullying and harassment, theft, for example. Capability tends to be performance-related issues, so you can see how the vast majority will come under misconduct.
And obviously, if this situation does arise, are there specific guidelines that employers should be following throughout the process?
Yeah, you should always be guided by your disciplinary procedure, and fundamentally, should this end up in tribunal proceedings, the tribunal is going to look to see that you did follow a three-step procedure. First step in that is that you advise of the hearing, you advise what the allegation is, and you advise of the potential outcome of that disciplinary. The second stage is the hearing itself, and the final stage is that the employee has the right to appeal. Whilst I've outlined the three-step process, I always advocate with my clients that there is an investigation stage prior to the hearing. It just puts you in a better position to be able to defend any proceedings.
And I suppose as an employer, I'm kind of thinking, what's the aim of this procedure?
A procedure is about ensuring fairness and consistency in the workplace, and it's about making employees aware of what the rules are in your organisation, what standards of behaviour you will accept.
So Louise, you mentioned the fairness. What steps can employers take to sort of guarantee or make sure that fairness is being addressed?
I think, Michelle, if you follow the disciplinary procedure, you have a reasonable chance of assuring that the employee has been treated fairly. For me, I always examine how I would feel if I was in that particular situation. I may not like the eventual outcome. However, if I can look at it objectively and say, was the decision fair in the circumstances and was I treated with dignity and respect, then I think that's a fair indication that you have followed a fair procedure. I suppose one watch that I would emphasise to you is that sometimes if potential penalty is something short of dismissal, a lesser sanction, some employers become a bit complacent and think it's only a verbal warning, it's only a written warning, and it's not going to go anywhere. Always be mindful that that is the potential foundation of an eventual dismissal, and that will be examined in tribunal. And if you haven't come to a fair decision or followed a procedure for that first warning, then your entire case will collapse effectively and you may lose your unfair dismissal case.
So you've mentioned there's a lot of different steps and processes and procedures that have to be followed. What are the consequences if an employer doesn't adhere to these processes or procedures or follow the guidelines?
Yeah, worst case scenario, Michelle, that will result in tribunal proceedings against your company. Even if you were able to successfully defend that, you still have legal fees in any event. If you were unable to defend your unfair dismissal proceedings, the upper limit on that currently is £88,000 in Northern Ireland. And that's all off bottom line unless you have some form of indemnity insurance. Taking aside even the tribunal proceedings, there's potential employee morale. If you have acted completely unfairly, that affects the trust issues with you and other members of staff. So
there's a lot to consider there, and I really do think in that case it is maybe a specialist like yourself to bring somebody in. So in terms of Global People Solutions, what way can you support businesses if they do find themselves in this situation?
In the vast majority of cases, in fact, I would argue in all disciplinary advice that I give, the client always asks me to come and support in that process. So we can certainly prepare the kind of investigation outline, the sort of questions that you should be asking. We will obviously prepare all the documentation for you so that we're sure that that covers all of the legal processes that you need to follow. We handhold you through the process. Even if that escalates, there are other people within Global People Solutions that can support that. And yes, we're always acting there in a note-taking capacity, which is a very, very critical role in the process. But fundamentally, because there are other people that take part at various other stages in the process, we can give you advice. We can never make the decision. We have no responsibility under your disciplinary procedure to make a decision for you. However, if you believe that you can dismiss and we believe that is a very hasty decision, or that there isn't enough evidence, we will absolutely guide you in that respect.